The real thing that I want to talk to you about today is the story. I think this is the most important part of opening. If you think about it, you have to present the case like a story, and then I'm going to talk about the previewing again to avoid argument and to avoid that which you don't know at trial. When it relates to story, I want you to think about it this way. Trial as a process is muddled and confused, right? I get to put on questions of my witness, then the other side gets to ask their questions, then I get to put on my second witness, so I get a little more back to my story, my theory, but then the other side gets to go. As a process, it is all over the place. It's confusing. It's tough to keep track of. You have two places in a jury trial, two places where you can get out a cohesive, clear, short, persuasive story about what this case is about. And you can have the most sophisticated case in the world, and you can tell that story in a couple of paragraphs. You can tell that story in a couple of minutes. So the level of detail is for something for you to decide in your case presentation, but very, very simply, this is your opportunity to put it in that story context, to make it memorable. And of course, you shouldn't argue. You're not supposed to argue. This is not your time to argue an opening statement. However, think about how persuasive certain facts can be by the way you organize them. I could focus on the facts of this trial that favor my side of the case and the way I view the world and the way I want you to understand the case when I get to closing and when you get to deliberation. I'm going to organize the case and the facts that way. I'm going to organize it in a way that persuades you, that gets you to see it through my lens. Right? So one of the big mistakes that law students make and new lawyers make when they go into opening and they start to think about their story is they do it like a newspaper reporter. There's fact 1, fact 2, fact 3, fact 4, and it doesn't matter. I have done no analysis as to which ones favor my side of the case and which ones cut against my side of the case. No, you are doing the editing. You are putting together this movie. You are putting together the lens that they look at this case, and do it in a persuasive way. Do it in a way that everything that comes out of your mouth favors the result that you want in the end. That's how you should approach opening, and that's how you're going to organize in a persuasive way to tell this story. So sure, you can't argue, but you can edit and present and organize in a way that is persuasive that results in you winning. The second one is keep track of the fact that trial is going to be all over the place. If you only have 2 chances to organize it in a story and a story they will remember, take it. Take the opportunity to say, I'm going to stand up before you now, I'm going to be clear, short, and concise about what this case is about. As big as it is, this is about a company, this is about 5 executives. They oriented their books and they booked their revenue in a way that resulted in cheating. And you know what? When they were asked questions about it later, they lied. This case is about lying and cheating, right? And that could be Enron. So it doesn't matter how big and sophisticated the case is, you boil it down to a simple story, and then it's for you to decide how many facts and where you put those facts to persuade by the way you tell that story. Now, there's a couple ways that you can get it into a story, and there's a couple tricks for this. You can put it into first-person tense. You can make it like the audience is there that day. So when Susie came home from school, she took the same right that she always takes. She walked down the end of that long block, and it was a path that was familiar to her. She takes 3 steps on the gravelly driveway to go towards her home, and she already knew something was different. Something wasn't right. I launch into a first-person account of the story. And you know what? The jurors start to embrace that as a story that they're seeing, as a part of a movie that I've edited and presented to them in that way. And they will remember, right? They may forget a whole bunch of facts. They may forget what a witness says on cross versus what another witness says on direct. They'll screw up everything that happens in trial and where it took place. But they'll remember Susie's first 2 steps on that gravelly driveway and how she thought something was different at the house that day. And you know what? It focuses on something that's very important in opening statements. Do it in a way to grab attention. Do it in a way to draw people in. Do it in a way where you want to know what happened in that house. What was different about that house? You are building a cliffhanger, and if I reveal it and I build up to that cliffhanger in this way, the door was ajar, she went in, she called out to her parents, they weren't there. Matter of fact, no one was there. And as she's calling out to her parents, she realizes that she's never going to talk to them again, right? We start revealing little details and tell it in the story, and you're drawing your audience in. And they'll have trouble letting go of that emotional connection that you made in an opening statement. They'll have trouble letting go of the way that you hooked them in the beginning. That's the story, no matter what they hear from the opposite sides of the case, that they'll keep going back to throughout. That's the way you want to think about it. And again, the next one that I put up here is Underpromise and Overdeliver. I think that's something that if you read any book on trial advocacy and you look at the chapter on openings, they always say, underpromise, overdeliver. And what does that mean? What does it actually mean? Think about openings. I want to hook you in. I want to bring you to my side of the case. I want to introduce you to the story that I want to tell, but I don't want to go overboard. And this is for one very simple reason that we talked about in some of our other lectures. I'm telling you about the story I'm going to tell you throughout this trial. I'm going to use trial and my witnesses and my evidence and my documents to then tell that story. Then I get to stand up again later on in closing and tell you what I told you during that trial. I want the story and everything, the facts, the way that I've organized this case, my theory, to get better as we proceed. I want to undersell here in opening, and all of a sudden in trial, it comes out a lot better. And I have surefire ways to make sure that happens. I don't say anything about witness credibility, for instance, in opening. You haven't heard from these witnesses. You don't know anything about these witnesses. It's not fair for me, and it is argument for me to stand up and say, you're not going to believe the plaintiff in this case. Right? That's argument. And I don't need to do it in opening because it hasn't happened yet and you're not ready for it. So I save that. I save that part, and I don't make it part of my opening. I certainly attack it and go after it. If I'm a defense counsel in a civil case, I go after the plaintiff, and I try to go after that credibility during the course of trial. And then when it's time in closing to actually argue, I'm going to argue that you shouldn't believe the plaintiff, that the plaintiff has credibility issues, that the plaintiff was impeached somehow during their testimony. So you see how the case got better with that argument. I get to say, not only are we still at the same place of the story that I introduced to you, but now the only thing that kind of runs at odds with that story that I told in opening is what the plaintiff said. Well, here's all the reasons you should have a problem with what the plaintiff said about this. Here's all the credibility reason that actually adds to my case and makes it better. The other reason, and the more obvious reason to underpromise and overdeliver, is we've all been in that place when we do trial work where the other side goes overboard and they promise the world, you're going to hear this, you're going to hear this, and you're going to be convinced by the end of this that they should have never brought this case, and I don't know what they were thinking when they did. You won't see a shred of evidence. They hear these drastic, sweeping overpromises. And you know what? When trial comes out more like my theory, or more like my story, and we're sitting there in closing, I'm going to have an opportunity to stand up again. Because remember that you get to tell this twice. And I'm going to say, remember when you heard certain promises from opposing counsel? Well, we never saw one shred of evidence. Let's go over every shred of evidence that we actually saw in this trial. And you'll see at the end, it's much more than a shred, and there was lots of it. You know, so you got to be careful. This is just another way that it can be used against you. And we're going to talk about don't argue, persuade by how you organize the facts. Let me talk about previewing as a way to get around both. Previewing, I want you to think, so the same way that I'm building up this story and I've organized the facts of this story with Susie going down the driveway and into the house, I've organized it in a way where I'm telling it and I'm drawing you in and hopefully I'm getting you emotionally invested in the case. Well, I can't argue during certain points, and I can't offer my thoughts about why things happened or, you know, for instance, the credibility of a witness that I just talked about. Those are argumentative. It's susceptible to objection in opening. It's not a good thing to be in opening where you're trying to have your first words with the jury, have your first connections with the jury, and the other side standing up and saying, objection, argumentative, judge says sustained. Bad place to be. So what's one way that I can keep the suspense, keep the intrigue, keep the emotional connection with my jury, yet not misstep and go into argument? I can preview. And one of the ways I would preview, take witness credibility as that example. I think throughout the course of this case, you're not going to believe the plaintiff. I think the plaintiff's account, as I already know it through depositions and prior statements, is not believable. That's an argument that I have. It's an argument that I'm going to certainly make in close, and it's going to be one of the reasons why my theory is going to win out, why my story is going to win out. But I'm not going to say it now. I'm not going to say it in opening, but instead, I can preview it. You're going to have a chance to hear from the plaintiff in this case. Plaintiff takes a stand. You're going to get to hear exactly what went on July 16th when he was out at that site. And you're going to hear the decisions he made and the things he said and then the actions he took knowing what was going on at that site, right? I preview it, I set it up as this is a place where you want to focus your attention when it comes up in this muddled presentation of trial, and I highlight it. And I tell them they're going to have a problem with it, and I tell them to look out for it. I tell them that's the place where they want to pay attention if they're trying to reconcile two different stories. Well, that can help jurors, and it's previewing, it can add interest. And not only does it add interest to your opening statement here in these couple minutes that you stand before them, but now all of a sudden you flagged and have highlighted something that they're going to have interest in later on during the course of your trial. So that's one way that we do. A lot of people think, and you'll hear and you'll read in books, you will hear, you will learn. I can argue as much as I want as long as I throw these buzzwords at the front of it. Well, it's actually not true. A lot of us don't like the words you will hear before every sentence you do in opening. It's not effective, and it's one of those, we don't talk that way. So when you start saying to jurors, you will hear this, you will hear that, you will hear that, it sounds like that we're talking in a different way, and it sounds like we're using our legalese and we're qualifying everything we say. So instead, I can't say something like, you will hear throughout the course of this trial from the plaintiff, and you're not going to believe him. Well, I put you will hear at the beginning, but it's still argumentative, and it still should be sustained as an objection. So what I want to do is not so much think about those words, think about ways that I can add interest, but then leave it for a time at trial. The other one that I use it for is the avoid overpromising, and that's specifically like, I have as a witness that I'm going to call in my case that's affiliated with the other side. It's the defendant's younger brother. We interviewed the defendant's younger brother. The defendant's younger brother has information that helps my case, but quite frankly, I don't know how it's going to turn out at trial. I don't know if that witness is going to deliver the goods on that day. Matter of fact, I have a real good reason, a biased reason, that witness is going to go sideways on me. That witness is going to see his brother in the courtroom, see what's happening, and maybe not give me what they gave me in a prior statement or what I believe that they know. So that's something that's up in the air. It's something that I don't know about. So as it relates to opening, I got to figure out a way to handle that. The first thing I'm going to do is I'm not going to overpromise. For me to stand up in opening and say, you're going to hear from the defendant's younger brother is a mistake, right? Because as soon as I say that, I'm starting to promise what's coming out of the younger brother's mouth when I don't know. And if I say he's going to say X, Y, Z, and he shows up at trial and doesn't, now I've overpromised. So that's a witness that I might leave out of my beginning part. I might leave out of my opening statement altogether. The other thing has to do with evidentiary rulings. If I'm not sure a piece of evidence is going to get in, if I know there's a bona fide objection to a document that I have from the company, I have an argument that it's a business record, but really I can see the other side of this evidentiary argument that they could say, no, it's pure hearsay and it doesn't qualify under that exception. That's something I want to stay away from in opening. I don't know how it's going to shake out. Even if I think I'm right in the law, judges decide things for different reasons all the time. And if I don't know that document's going to be part of my trial, it's not part of my opening. Because that's one way I can ensure that I won't overpromise, but I will overdeliver. If I leave that document out of opening, if I leave younger brother's testimony out of opening, and then they do come up at trial as I've planned, as my analysis shows that I should, and as my strategy says that, how it contributes, I get to closing and I say, it gets even better than the story I told you in opening. Now you have the document too. Now you have younger brother. His own brother said this. So it can get better and I can over-deliver by staying away from the things that you don't know about. Stay away from witness testimony that you're unsure about, and stay away from things that could potentially be locked up by evidentiary rulings.